Good afternoon, Mr. President. Good afternoon, my colleagues of this honorable House. I rise to contribute on this bill, the Civil Court Bill. And like my friend Senator Farai, we on this side, we support the bill. We support the bill. However, I have my concerns as a practitioner in the civil division of the High Court. And I am happy that Senator Alaha did not avoid that distinction, trying to clarify the distinction with the High Court. It was a concern that I just observed when the papers were given to me yesterday. Certainly we know the bill itself, it defines the civil court as a high court under the definitions of the bill. So it means a high court established under Section 5, exercising jurisdiction in civil matters. And under Section 5 of the bill, it says that upon the commencement of this act, authority and jurisdiction in civil matters exercisable by the High Court shall be exercisable by the civil court. Now, my concern there, and I think Senator Alaha has attempted to address the concern, was that the bill in itself, when it speaks to the High Court, it also has to have an interplay, firstly with our Republican Constitution, which under Section 90 defines the court. Section 90 says, Section 99, it says that there shall be a Supreme Court of Judicature for Trinidad and Tobago consisting of the High Court of Justice, hereinafter referred to, and they put in quotations, the High Court, and a Court of Appeal with such jurisdiction and powers as are conferred on those courts respectively by the Constitution or any other law. Section 100, I think, addresses the situation where Senator Alaha has says that the judges of the High Court shall be the Chief Justice, who shall be ex officio a judge of that court, and such number of Sweeney judges as may be prescribed. And the High Court shall be a superior court of record, save as otherwise provided by Parliament, and shall have all the powers of such a court, including all such powers as are vested in the Supreme Court of Trinidad and Tobago, immediately before the commencement of the Constitution. So I say this in the context of, given that we, in this civil division bill, we are creating a civil court that also has the powers of a high court, we have to look at it in the context of, is it that it is being assimilated with the high court that already exists, or is it a high court that will exist external to the high court that currently exists? That's something that myself as a practitioner, I'm just concerned about. And if that could be a little more defined in the Act in terms of the interplay between the civil high court and the existing high court. I think that they should have some sort of clarifications there. Also, with regards to Clause 26 of the bill, Clause 26 of the bill speaks to the right to appeal. And I believe once the claim is over the prescribed amount of $2,000, it gives you the right to appeal as of right to the Court of Appeal. Now, I heard the Honorable Attorney General indicate that there was a level of consultation albeit during COVID. My concern is if there was consultation with the current Chief Justice. As we know, the Chief Justice has changed. The office of the Chief Justice, there's a different holder. It is in those circumstances, I think it prudent, because the reports that we have from the judiciary, certainly the ones that we have available to the public, I think the last one is 2020 during COVID as well. So if it is that we are giving citizens this right to appeal to the Court of Appeal, so long as the claim exceeds the amount of $2,000, I think some level of consultation with the appellate courts should, because that, in my respectful opinion, will burden the courts, especially where citizens have that right as of right to appeal. My other point I would like to raise is the issue with regards to the estate of administration. And certainly that is a welcome addition to what currently exists, or a welcome replacement to what currently exists. I observed that there would be a sub-office in Tobago, San Fernando, and in the north. In the north, I presume, would be Port of Spain. I speak on behalf of members of the bar that practice, say, in East Trinidad, that may not have the opportunity to submit their original documents to a sub-office, say, in Sangre Grande, or a sub-office in Arima. Certainly, members who practice in Central Trinidad, a sub-office in Chaguanas, may be something that can assist not just with the practitioners, but certainly with the persons who seek access to justice in regards to administering their deceased relatives' estate. So I'll just say that in that context. And then I would finally like to raise a point that the Judicial Committee has raised with us in the past with regards to when we put laws in place, but not the systems to support the laws. And I am quoting Lord Burroughs from the case of Attorney General of Trinidad and Tobago versus J.M.A. Minor. And at paragraph 29, Lord Burroughs, he basically warns us. He says it was held that their remand was not only unlawful as being in breach of the primary legislation, but was also an infringement of their constitutional rights to the protection of the law under Section 4B of the Republican Constitution. The board referred to the expansive approach that has been taken to the protection of the law provision extended beyond access to the court system in earlier cases such as the Maya Leaders case and the Maharaj versus Prime Minister of Trinidad and Tobago case. Among other facts which the board considered to be relevant in what was stressed to be a fact-sensitive case-specific question, it focused on the fact that the executive had frustrated the legislation by bringing the provisions into force without ensuring that the requisite detention facilities for children were in place, and that this meant that the two claimants were exposed to conditions, environments, and influences which the legislative provisions were designed to avoid. I say this in the context of when we give citizens rights, we can't simply take it back. So when we give citizens the right to bring a claim in the small claims court, it creates that legitimate expectation that they will be given an opportunity to be heard, and an opportunity to be heard in a manner in which Parliament intended. And hearing from Senator Alaha, the intention is for the process to be a little more expeditious than the current process that exists. The intention is that the process to be less expensive than exists, because the small claims court, it would not make sense that the candle costs more than the funeral, for want of a better term. So when we give our citizens these rights, know that they will access it. And if they are unable to access it, we will be held accountable because we created that constitutional right to a new form of access to justice. So I pray that we have the relevant systems in place, that when this bill is proclaimed as law, that all citizens will be served by it. And I so submit to this honourable court.